Celebrate the launch of David Rothkopf's new book, American Resistance, the inside story of how the deep state saved the nation, by becoming a member today. This month, new members will receive a free signed copy of the book, along with the usual member benefits, including an ad-free listening experience, members-only bonus content, an invitation to join the DSR Network Slack community, and more. To take advantage of this offer, visit thedsrnetwork.com/buy and select the option titled American Resistance. Upon successful checkout, you will receive a confirmation email with instructions on how to redeem the book. The book retails for $29, but is included with this membership option. You'll just pay for shipping. Please allow 2 to 4 weeks for shipping. Thank you very much.
9, 12, 10, 28, 2, 23.
This is Deep State Radio, coming to you direct from our super secret studio in the third sub-basement of the Ministry of Snark in Washington, D.C., and from other undisclosed locations across America and around the world.
Hello and welcome to today's episode of the podcast. I'm your host, David Rothkopf, coming to you today from Washington, D.C. I am joined today by our friend Dahlia Lithwick of Slate magazine, of Amicus podcast, of her great book, Lady Justice, which is a runaway bestseller, and later today of my sister's podcast.
No pressure. No pressure. Hi, David.
No. This will not be anywhere nearly as entertaining as my sister. And it seldom is. Today, the reason we are talking is that there's been a variety of kinds of legal news. But while a lot of the attention has been drawn to Trump legal cases and so forth, it seems to me that this Supreme Court case that was heard yesterday is potentially extremely significant. I know you followed it. Perhaps you could describe it in a nutshell and why you think it's significant.
It's not just me that thinks it's significant. I think that Michael Luttig, former Judge Luttig, who you may recall almost got Chief Justice John Roberts' seat at the court. He was on the short list. He was also the person who told Mike Pence maybe not to decertify the election right before January 6th happens. This is a conservative stalwart, one of the most well-respected minds of the conservative legal movement. He has said it's the most consequential democracy case, ever, and certainly of our lifetimes. And this is a case that fundamentally, if the court were to accept the theory that I'm about to explain, would alter forever the way elections are administered and the way you check elections that are administered lawlessly. So this is a big deal. And it's also, I think, as you suggested, lined up next to Mar-a-Lago and lined up next to, the Trump org and lined up against other legal news. It's so abstract. So it's been hard to kind of have people understand how really salient it is. The very shortest version is that the state of North Carolina and its Republican legislature put together crazy gerrymander. We've got a 50-50 state. It was 10 Republican seats to the Democrats. The state constitution prohibits that kind of gerrymander, political partisan gerrymander. The state Supreme Court struck it down under state constitutional law and said, make new maps. Republican legislature said nope and took it to the Supreme Court. Essentially, their argument is there is no checking function on the state legislature. They have what's called plenary or exclusive power on all elections proceedings. And no matter what they do, it cannot be checked by state courts. That's the argument that was argued yesterday at the Supreme Court.
And the consequence of it would be that state legislatures could act with impunity and recklessly and in ways that undercut democracy, and they would not be challengeable by state Supreme Courts, correct?
Right. And with the caveat that you may remember a couple of years ago in a case called Rucho, the Supreme Court said, by the way, we as the Supreme Court don't get in the business of partisan gerrymandering either. In other words, the U.S. Supreme Court has announced this is quote unquote non-justiciable. This is not an issue they're going to touch. Partisan gerrymandering, by the way, in Rucho, the court says, but don't worry, you can always take it to your state Supreme Court. So this would essentially take that other check, the state Supreme Court, out of the picture.
Let's take a step back. This sounds crazy. It sounds completely out of step with the way our system works with checks and balances and judicial oversight and so forth. But nonetheless, the right-wing majority on the court, led by, once again, Justice Alito, seemed sympathetic, did they not?
Very sympathetic. We should note, I guess just to do the doctrine for a quick second, you're right, David, it's just crazy. It's not rooted in constitutional history. It's not rooted in constitutional text. There's no 233 years of doctrine around this. This is kind of fashioned out of whole cloth by a conservative legal movement. I should say it's rooted in an opinion in Bush v. Gore that then Chief Justice Rehnquist wrote in a concurrence, right? Didn't get 5 votes, got 3 votes. And they're holding that out as though that is like the law of Bush v. Gore. There's no there. And the other piece of doctrine that's worth just flagging is that there's 2 elections-related clauses in the Constitution, the Electors Clause and the Elections Clause. This appeal is the Elections Clause that says that, the state legislature can set the time, place, and manner of elections subject to congressional approval. So what they're basically saying is everybody didn't see for 233 years what we now see, which is that this means that no one else can check, not the governor and not the state Supreme Court. And you're also right that Justice Alito is gung-ho for this. We actually have already 4 justices of the Supreme Court, Alito, Thomas, and Gorsuch, who in earlier iterations of this case have signaled approval for this independent state legislature doctrine. And Justice Kavanaugh in an earlier iteration who said it's a hard, tough question. So we actually have not 1, not 2, not 3, but 4 justices who look like they're already in the tank for this novel theory that has no basis in history.
And do we have any idea where the Chief Justice
We actually know where the Chief Justice is because in an, again, earlier version of this same case, when it came down on the shadow docket this spring, the Chief Justice voted with the liberals, and it was pretty evident yesterday at argument that he thinks this is nutty. And I think I can also say, given that everybody was watching Amy Coney Barrett, if the hypothesis is right, that there's already 4 folks who love this, Justice Barrett did not intimate yesterday at oral argument that she's all in for this. She suggested she had real problems with it, and she pushed the attorney who was pressing this argument for the Republicans of North Carolina legislature. She pushed him really hard. So to the extent that there's a silver lining here, 1, it's not clear to me they have 5. It's not clear to me that Barrett's there. Not even clear to me, by the way, that Justice Kavanaugh is there, at least for the maximalist extreme view of this. But also, I was really, really struck by the fact that there was no way that the lawyer who was arguing this seemed credible under any set of facts. I mean, he was just not good. And the conservative justices, the 3 who really love this idea, weren't really able to bolster what he was saying.
Does that matter anymore?
No. Probably not. And also, parenthetically, we have seen Justice Barrett do this chin stroking before. I mean, we've seen her look as though she's in play, only to side time and time again with the conservative supermajority. So I don't want to give false hope. I think what I do want to say is that given every opportunity to slightly cabin or minimize the argument he was making, the lawyer for North Carolina's Republicans in the legislature couldn't do it. In other words, he was like, go big or go home. I'm asking for the moon. And it just seemed to me that both Kavanaugh and Roberts, and I think seemingly Barrett, waiting for him to do something sane, didn't hear anything sane.
Let's imagine for a moment that they fine for this guy who you thought, didn't make his case. And this independent state legislature thing, it would seem to me as big a blow towards democracy as we've had, because this North Carolina case that you talked about literally said, it says, that we are going to treat half our state to 4 seats and the other half to 10 or whatever it is. And if they can do it, anybody can. And there is no check except apparently the Congress. And so long as you have Republicans controlling one house of the Congress, they're not going to fix it.
I'm going to read you, I thought, the most important question of the day. There were good questions all around, but this was Elena Kagan, I think, mapping out where this could go. And I'm just going to directly quote her comment in the argument. She said, "This is a theory with big consequences. It would say that if a legislature engages in the most extreme form of gerrymandering, there is no state constitutional remedy, even if the courts think that's a violation of the Constitution. It would say legislatures could enact all manner of restrictions on voting, get rid of all kinds of voter protections that the state constitution, in fact, prohibits. It might allow the legislatures to insert themselves and to give themselves a role in the certification of elections and the way election results are calculated. So in all these ways, I think what might strike a person is that this is a proposal that gets rid of the normal checks and balances on the way governmental decisions are made in this country." So what she is in effect saying is exactly what you just said, which is if you bless this, you are going to see, and let's just note that 30 of the 50 states have red state-controlled legislatures because of years of gerrymandering. 30 out of the 50 states will just go hog wild on voter suppression, on gerrymandering, on we're just going to stop Sunday voting, we're going to stop mail-in balloting, right? There's nothing that can be done. The most pernicious fear, and I think Justice Kagan was flicking at it, is that under the Electors Clause, the other provision in the Constitution that said that suggests here that states also have plenary power over who to certify as the electors, they can do what Trump was asking folks to do in Georgia in 2020, right? What they were asking people to do in Arizona, just make up a fake slate of electors and send them to the vice president. So you're quite right. The implications are not just congressional elections. It's also fake slates of electors. And under the Electoral Count Act, which is that fossilized, terrible statute that determines how electors are counted, there's huge gaps that could allow that to happen. So this has the potential to be catastrophic at every level. And again, to the extent that I saw only really Alito and Thomas and Gorsuch psyched about the catastrophe, it wasn't as terrible as it could have been. And I know that when you hear me say it wasn't as terrible as it could have been, it's like, hey, Supreme Court, stop punching me in the face. But it really didn't feel like there was a lot of enthusiasm for this absolutely maximalist view.
Okay, we'll keep an eye out and rely on the wisdom of Amy Coney Barrett and Justice Kavanaugh, which even as I say it makes me kind of throw up in my mouth a little bit. There was another case in the Supreme Court this week in which a web designer said, well, if somebody came to me and said, design a website for a gay wedding, I don't believe in that, so I'm not going to do it. And, there again, the right in the court seems sort of sympathetic to the idea, and the right wing seems to be presenting this as a free speech issue. In other words, you're entitled, if you're creative, to decline your services to people who have views that you may not agree.
If this sounds familiar to people, this is part 2 of Masterpiece Cake Shop. This is also a Colorado case. That was the Colorado baker who didn't want to bake a cake to celebrate a same-sex wedding. He said it violated his religious beliefs. And folks may remember that case got all the way to the Supreme Court on 2 grounds, right? On these speech grounds, right? Cake baking is an artistic, creative enterprise. I'm speaking with my frosting. And 2, I managed to say frosting. Good. Okay. And the second claim was this religious dissenter claim, right? I cannot be forced to do something against my First Amendment religion protections. And Justice Kennedy kind of split the baby on this case because he essentially punted and said, on the one hand, state public accommodations laws really matter. Only about half the states have public accommodations laws. They matter, right? If you hang out a shingle and say you're doing business, you serve all comers. That's what the public accommodations laws protect. And that you can't discriminate based on race or gender or disability or LGBTQ status. But, said Justice Kennedy, I don't really like how the commission talked to the baker. They kind of insulted him. So the case was a wash. So now it comes back. And as you say, it's now been completely retrofitted so that it will win. So A, we don't have just Justice Kennedy anymore. We have this conservative supermajority. And B, we've stripped away the religion part of this case. It's just a speech case. And as you said, it's entirely speculative because Lori Smith, who is the web designer in this case, who makes websites for all sorts of things, has never made a wedding website. She's certainly never made a wedding website and then denied services to same-sex couples. She just wants to make wedding websites and wants to deny services to same-sex couples. And the important part of that is that there are no faces on the other side of this case, right? We have no Charlie and Dave the way we had in Masterpiece Cake Shop. No one is facing discrimination. And as you said, the 10th Circuit heard this case. It went up to the Supreme Court. There are no facts. There is no record. So what the Supreme Court spent the day doing on Monday was just sort of spitballing hypos. And the hypos, David, were gross, right? We were talking about Ashley Madison. We were talking about J-Date. Ha, ha, ha. We were talking about a mall Santa Claus, Black Santa Claus in the mall who doesn't want to sit next to Black children in KKK road. Like the whole thing became this kind of funny thought experiment about denial of services without any recognition that there are actually dignitary interests on the other side. I have no silver lining for this one. I think that my sense of it was that the court conservatives absolutely believe that there is going to, for the first time ever, be a carve out to public accommodations laws for people who are engaged in creative expression. And we're going to fight about whether that includes the florist and whether that includes, in one of the hypotheticals, the person who brings the chairs to the wedding. Does that person engaged in some kind of creative speech act? But I don't think there's any question that there's going to be a carve out. And so the short answer is not only will this be really disastrous for gay couples in states, and as I said, not all states have public accommodations laws. So a lot of states, you already didn't have these protections. There's no federal protection against this kind of discrimination. So not only are LGBTQ folks going to face, I think, discrimination, it's also going to, in my view, because there's no principal distinction between denying services because of your religious objections or because you don't want to do this on the basis of race or disability or gender, that I think this is going to open the floodgates for people to end run public accommodations laws and just say it violates their strongly held beliefs.
Even though the Congress this week seems to be passing a Marriage Equality Act that says that all the states have to recognize marriages no matter who they're between.
It will do that. It will afford protections to marriages even in states that don't recognize same-sex marriages, but it will not stand in place of public accommodations laws. It's not going to do the work of, protecting folks from discrimination by businesses. And as I said, time and time again in the argument, when asked by Justice Ketanji Brown Jackson, by Sonia Sotomayor, by Elena Kagan, how is this different from famous civil rights cases where people would not serve, blacks unless they went round the back way and took out their food from a window and said, this is not discrimination. We're just not letting you sit in our restaurant. There's no answer. The answer seemed to be, well, because that's racist. That's not actually a constitutional answer.
Yeah. That's why when I was talking in a prior podcast about, everybody's sort of euphoria over the last election result, it doesn't impede this Supreme Court from being a nemesis of democracy for decades.
I mean, I think here's where I give you the answer that is exactly the shape of that big sigh you started that question with. And the answer is, if we don't think about structural court reform, we are going to live under the thumb of this court for a very long time. And, you can talk about whether that's term limits. You can talk about whether that's stripping the court of jurisdiction. You can talk about whatever, packing the court ethics rules. Right now, there's a hearing going on about imposing trivial ethics requirements on a Supreme Court that does not have any binding ethics rules. All of those things can't happen. But you're quite right. If we can't have a robust public conversation about what we're going to do about the court, it's not just, David, that they're out of control, stipulated, right? You and I have been having this conversation for some time. It's that they're emboldened. I mean, the pedal to the metal here. This is not a court that's doing 1 or 2 big cases a year the way we used to see. This is a court that's doing 12 big cases a year and feels that it has complete impunity to do what it wants. So, yeah, I think that you're exactly right. We can talk about, we dodged a bullet in the midterms. But if this is a court that is hell-bent on Shelby County and Brnovich and voter suppression, and now Moore v. Harper, the independent state legislature theory, if the court is okay with that, this is a court that is systematically subverting voting. And if we don't figure that out, all the midterms in the world don't get us out of this.
Well, it's also striking. I mean, you've been writing about this for a while, and there are just a few things that come up on a regular basis. Stare decisis, precedent. That doesn't seem to matter.
Post-Dobbs, I think stare decisis. I was thinking today, just as I was watching the ethics hearings, and the defense that the court offers is, sure, there are ethics rules and statutes and canons that bind every other Article III judge. We consult them. They're advisory. They're not binding on us. I think they feel the same way about stare decisis. We consult it. It's advisory. It's not binding.
And we can use it. Or we can ignore all of it and go back to, what's this guy's name?
Matthew Hale. He came up yesterday in the hearings again. The witch burner. He's, yeah.
Some 17th century judge. Yeah, well, he's the guy.
Yeah.
I mean, it's really rabbits out of a hat, isn't it? I mean, it's kind of crazy.
Well, it's interesting. I will say, to the extent, again, I'm fumbling around for false hope, and you're rejecting every time I give you like an offering, a tribute. Here's some false hope. I will say all the historians in this case, much as they were in the gun case, are just on the side of this is insane. I mean, there's no meaningful historical evidence. Now we're talking about the independent state legislature case supporting this. In fact, the document they use is a fraud. They have one document that seems to bolster their theory, and it's been disproven. So I think that you have all the historians, all of them, even conservative, like I said, like Judge Luttig, Stephen Calabresi, co-founder of the Federalist Society, is on the side of the angels in this case. It's wingnuts. It's John Eastman who are on the other side. And so the part of me that, and by the way, Neil Katyal, former Solicitor General Katyal, who was arguing this case yesterday, name-checked every single one of those conservative luminaries at least once, sometimes twice, just to be like, as you will see in this brief or that brief, and then persistently name-checked everyone that is supposed to be a leading light for the conservative movement. Whether that induces them to pump the brakes, I can't say.
But you might think that, that kind of rational thought would lead to Supreme Court justice suggesting to his wife that she not be involved in overthrowing the government. Right? You might think that these justices should not leak information to bolster their case. They've just, it seems to me that they've just like thrown a bandit to the wind. They're just like, we're going to do whatever we want because we can.
So this actually brings me back, if I may, to court packing for a second. Because one of the reasons I think everybody is afraid to say those two words, court packing, or as you might more genteelly say, expanding the court, which works better. Everybody immediately goes into this like rictus face, terrorized, like, FDR, right? That the most popular president in history almost destroyed his presidency over court packing, right? And the public was laughing at him and everybody.